Good morning, everyone, and welcome to our winter HRLaw webinar. Thank you very much for joining us for this annual run through of some of the key themes and cases over the last 12 months, and also legal developments that we've seen, but also to explore what is in store for us all in the year ahead. I think this time last year, we never expected we would not be welcoming you all to our office to enjoy the session and to enjoy a mince pie together. Maybe next year. But I hope you find the webinar useful, and we'll try to keep within an hour, as we know you've all got very busy days in the lead up to Christmas. We are recording this session, and there is a Q&A function, so please do pop your questions in there and we'll try to answer these at the end of the session. Now, you'll be well aware it's been another eventful year, and of course COVID-related issues continue to feature very highly on the agenda for all our clients. The return to the office remains a very important theme, with hybrid working patterns and getting employees back to the office, which seems to have taken a bit of a backward step now with the new Omicron variant. All of this has thrown up some very tricky legal issues, and my colleague Jess Ambrose is going to discuss current working trends and some of the difficulties around vaccination requirements and reluctant returners. Alongside the pandemic, there have also been some very significant cases this year, such as the Supreme Court decision in Uber against Aslam back in February. That was a very important decision, both for the gig economy and for working out the employment status of your workforce in general. And Daisy Jones is going to highlight some of the key principles in relation to employment status. She's also going to highlight several recent discrimination cases and provide an action plan for you to consider. Our PSL, Kerry Kirby, is going to focus on some hot topics for the year ahead. You will no doubt be aware that the government has consulted on changes to the current law on flexible working and has confirmed the introduction of a new duty on employers to prevent sexual harassment. And then finally, we think that strategic ill health will unfortunately be an ongoing issue, and therefore strategic absence management is going to be a really important issue for all businesses next year. So Jane Mann is going to discuss your legal obligations and some top tips for implementing a health action plan. Now, before we start, I'd like to do a poll with you just to start the session off. So if Jess could please pop the poll on the screen. There are just 3 questions here, and we'll be picking up on some of the issues in what we're saying this morning. So if you're able to, if you can click on the 3 questions. So the first one is if you operate hybrid working, what's the minimum days per week that employees are expected to be in the office? Secondly, do you request evidence from your employees that they've been vaccinated? And thirdly, do you offer enhanced company sick pay? I'll give you a few seconds to answer those questions, and then we can pop the answers up on the slide. Okay, hopefully enough time to answer. Jess, would you pop the responses up for us? Okay, so we've got a bit of a spread but around the hybrid working, mainly 2 days, which probably reflects what we're seeing amongst our client base in general. Most of you not asking for evidence of vaccination, and most of you offering enhanced sick pay. So thanks very much for answering those questions. I'm going to hand over now to Jess, who's going to start the session off. Thank you.
Thank you, Jo. Hello, everyone. My name's Jessica Ambrose, and I'm an associate in the employment team. Today, I'm going to be talking about returning to the office, and so we'll look at some trends that we're seeing in the market at the moment, and also some common questions on the vaccinations. So first of all, Plan B. Next slide, please, Jess. So first of all, Plan B. Is it likely that we'll get working from home guidance? Well, for the moment, it looks like we just have the Plan B light, but with the uncertainty around the new variant, it's possible that a full Plan B could be introduced, which may include guidance for employees to work from home where possible. We know that Scotland and Wales have already implemented this. We consider that it's likely to be guidance rather than law, meaning that it might still be possible to have some staff in the office for the purposes of meeting business, client and regulatory requirements. We know that some employers have also allowed staff to come into the office for their mental health and well-being. So what trends have we been seeing in the market when it comes to returning to the office? Hybrid working has been the most popular option for employers, particularly in professional practices and those working in the city. And the ratio between working from home and working in the office varies depending on the industry, the business needs, and employee expectations. In general, employees have been expecting to see an increase in their working from home days, and most employers have been able to accommodate this. A common theme we've seen is that employers are allowing employees to choose their days, which they work from home or in the office, and that those days may change from one week to the next. Some employers, although not as many, have opted for a fully remote workforce or significantly increased their remote working. For some employers, it only may apply to certain teams rather than the entire workforce, or perhaps certain individuals who now have a fully remote working pattern. The main benefit of increased remote working being saving office space and therefore reducing the cost of overheads. Fully remote has perhaps been more popular in sectors such as technology, although we have seen some financial services firms also implementing fully remote working patterns for employees who are not in customer-facing roles. Quite a lot of the banks are requiring their employees to go in, and they have been requiring them to go in throughout. But in contrast, some employers have been keen for their workers to return to the office as it was pre the pandemic. So we've seen a push for a full return where headquarters are overseas and wanting all of their offices to be aligned. Some employers are taking a phased approach, so they're introducing employees back into the office steadily. Others have set a date for the new year when they expect to commence a full return. Again, the option of a full return has not been as popular as the hybrid working. And finally, on this section, measures to encourage return. So this is another popular trend that we've been seeing in the market where employers are introducing perks. And I'll just list a few that we've seen. Enhancements to the office space, free breakfast and subsidised canteens, agile working patterns, so allowing the employees to travel outside of the rush hour, increasing the number of social events. And so they're all things that can help encourage travel back to the office, and also retention of staff who might find this elsewhere. So moving on to the next slide. Whatever your new normal is, it's a really good idea to keep it under review, and we would recommend carrying out periodical impact assessments to consider whether the new normal is still working for the business. I've put some points on the slide that you might want to consider when you're carrying out one of these reviews. So reviewing productivity levels, client satisfaction, risk management, regulatory requirements, employee morale and expectations, and also the market trends. Don't forget that information and communication are key. If the business is looking to encourage more employees back into the office, then explaining the needs of the business and the benefits of office time will be helpful. For example, collaboration, risk management, networking, supervision, training and career development. If the employees are provided with this information, then they are much more likely to be able to understand the business's drive to increasing the number of days back in the office. Don't forget to also inform employees about the COVID secure policies and the safe working practices that the business has implemented to ensure their health and safety. Consult with the employees on an ongoing basis and seek their feedback on the new working arrangements in place. Consultation is great for employee relations, and the more involved the employees feel in the process, the more likely they will be on board with the direction of travel that the business is going. The new normal is likely to be a moving feast, but do remember to update your policies as appropriate, even if a new measure is being introduced temporarily. And finally, don't forget the support that you can offer to employees. COVID has been a tough time for everyone, and so returning to the office or working from home is a significant change, and some employees are finding it difficult to adjust to. I thought we'd finish off looking at the new working arrangements by taking a quick look at a risk example in the case of Follows and Nationwide Building Society. So this was a case that was in the tribunal this year, and Follows was employed on a home worker contract, and she usually attended the office 2 to 3 days a week. The employer then decided that senior managers were required to be fully office-based. And Follows was put at a substantial disadvantage because she was the principal carer for her disabled mother. And indirect associative disability discrimination was established in this case. The tribunal held that the aim of on-site supervision was not legitimate and dismissal of Follows was not proportionate. They said that a hybrid arrangement could have worked. So it's just to keep that in mind that at the moment, we do think tribunals are going to have some sympathy with employees. So moving on to vaccinations, and can you require it? Well, interestingly, one of the most common questions that we've received on vaccinations have been, can employers require their employees to be vaccinated? The only settings where vaccines are legally required at the moment are for certain healthcare professions. And the reality is that most employers do not employ care workers or frontline NHS staff. And therefore, any policy mandating that staff must be vaccinated will carry with it a significant risk of discrimination claims, which we'll look at briefly in a moment. Our advice to employers throughout the pandemic has been to stay closely in line with the government guidance. We've actually had some practical experience in the tribunals this year of how following the government guidance and documenting those decisions alongside the government guidance at the time has proven favourable to the employer. The current guidance at the moment is still to strongly encourage employees to have the vaccine, and the government hasn't gone any further than that, except for the care settings. Another common question is whether workers can be prohibited from returning to the office if they have not received the vaccine. And in short, the legal risks still remain if evidence of a vaccine is required before they return to the office. For example, such a policy could unfairly impact pregnant employees, younger employees who may not have been offered a booster yet, and those with certain medical conditions who may be disabled under employment law, and perhaps certain religious groups. We have seen a number of US and Canadian parent headquarters introducing these policies which only allow vaccinated employees back into the office. But the general market trend at the moment is to wait for the government in the UK to change their guidance, and that's only if and when, and implement when it changes. But our view at the moment is this is probably unlikely. So moving on to vaccination evidence, can you ask for it? Well, interestingly, our poll showed that only 3% of you are asking for vaccination evidence, and I'd say that's fairly consistent with what we're seeing, although we have seen a lot of questions on this, so it's definitely something on employers' minds. Collecting anonymised data of vaccination levels across the workforce may be something which some employers wish to do. Collecting on an anonymised basis certainly carries less risk than identifying those who are vaccinated, but do bear in mind this may not be appropriate for smaller workforces where it could be much easier to identify employees. The NHS Code Pass is another tool that employers may wish to consider using. We know that some employers are interested in implementing this for employees returning to the office, and they're wanting employees to provide evidence of the pass in order to be allowed access into the office. Otherwise, they should work from home. We actually know quite a number of people are going to use the NHS Pass for their upcoming Christmas parties if they're still going ahead this year, and also for larger in-person events such as conferences. There's an argument that the NHS COVID Pass is less discriminatory than requiring employees to show evidence of a vaccination, as those who do not wish or who are not able to be vaccinated could take a lateral flow test or have natural immunity to produce a valid pass. But still bear in mind that the tests are intrusive, particularly as they have to be repeated every 48 hours to produce a pass. And so employees may feel as though they're being treated less favourably than those who've had the vaccine. Remember that vaccine data is health data, and therefore it does have additional considerations to bear in mind under data protection laws. The Information Commissioner's Office has produced guidance specifically around vaccine data, and we'd recommend reading that and following it carefully before processing. I've put some of the key questions to consider on the slide. It's also worth mentioning that the Information Commissioner's Office has said that a visual check of the NHS Code Pass without recording the data does not amount to processing under GDPR. So it's fair to say that returning to the office after the pandemic and vaccinations has brought with it a whole set of new legal issues to consider. I'll now hand over to my colleague Daisy Jones and look forward to taking your questions at the end.
Thanks very much, Jess, and good morning, everybody. So my name is Daisy Jones and I'm a legal director in the employment team at Fox Williams. And I'm going to be spending the next few minutes recapping on where we are with employment status before touching on a few key Equality Act cases and some important takeaways for your businesses. So starting with employment status, this has been a really quite a hot topic that's been rumbling on with a reasonable amount of judicial attention in the past couple of years. And we've had a high level of reporting on it in the press. I'm sure you'll all be aware that we've had some big ticket gig economy names litigating as to the true status of their workforce. And a lot of that litigation has been focused on whether these individuals are what we call workers, and we'll touch on what that means in a moment, or if they're genuinely self-employed. And a lot of the big players in the gig economy, they basically had started from a position in their own operating models where they considered the individuals they were engaging to be genuinely self-employed. And that might often be the preferred status from the corporate entity's perspective. But in most of the cases that have been litigated in the courts, we've had decisions that have found that the individuals engaged have been workers. And whilst these are all really fact-specific cases, that's been the finding in Uber, in Addison Lee, and in Stewart Delivery. And all of those cases went up to very senior courts. So Uber went to the Supreme Court, Addison Lee and Stewart Delivery to the Court of Appeal. So we're getting a lot of judicial attention, and we're getting a lot of very senior judicial attention in this area. Now, as I touched on, the key focus for most of this litigation is not whether someone's employed or self-employed, but whether they sit in the slightly grey zone of being a worker. And you'll see we've got the legal definition of that on the slide. And one of the key points to remember whenever you're considering worker status is the bit that we've underlined in the definition, and that's this requirement to perform work personally. And what that means is that where you as a business require a specific named person to do the task in hand, and you don't have an unfettered right of substitution as the provider. Now, that's not to say that every person you engage where you do require a named individual to perform the task will always be a worker, because these matters are decided with reference to quite a broad multifactorial test. I would say more the way to look at it is where you do have an unfettered right of substitution, it's going to be very difficult for an individual to successfully assert that they're a worker. So Jess, if we can move on to the next slide, please. If we're looking at status, bearing in mind the recent case law that's developed in this area, what have we got in terms of key principles? Well, the Supreme Court's position is that the starting point for the purpose of the legislation is looking at why it's in place. So basically it's there to protect vulnerable individuals. And the messaging that we're getting from the judiciary is that your working assumption when you're looking at status should be effectively that you're likely to be engaging individuals as workers, but let's see if there's any factors that might mean that they fall outside of that category, rather than starting from the other end of the spectrum where you might think, well, I'm going to assume they're self-employed unless proven otherwise. So we've got a little bit of a reframing of the picture. As I mentioned, there's also this idea of a multifactorial test in assessing status. And if we were to think of it visually, we'd have self-employed individuals at one end of the spectrum, true employees at the other end of the spectrum, and somewhere in the middle sit workers. And there are various points which will influence where on that sliding scale a particular person sits. But very broadly, the greater the level of integration and control, the more likely someone's going to be a worker. And obviously with very high levels of integration and control, you might actually tip up in towards employment. The less integration and control, the more likely the person is going to be self-employed. And within that test, we've got this point around personal service and the right of substitution. And that can really be very critical when you're making an assessment of status. So we've got the legal test for worker, and as we've talked about, there's this element of having to perform personal service to fall within that definition. And the argument goes that if someone has a genuine unfettered right of substitution, so they can decide themselves whether they perform the service or someone else performs the service, they can't possibly be performing personal service, so they can't possibly be a worker. And this was the case in Deliveroo, which actually is a judicial decision we've got that goes the other way to Uber, Addison Lee and Stewart Law. And in that case, the Court of Appeal found that Deliveroo drivers weren't workers because genuinely they have a freestanding right of substitution. So Deliveroo doesn't care who delivers your takeaway to your house. The drivers can work that out themselves. And if they want to ask someone else to do a particular delivery, that's fine. They don't have to go back to Deliveroo to ask for permission. And this idea that Deliveroo didn't really mind who did the delivery meant that there couldn't be personal service, and so the drivers couldn't be workers. Now, if you're in that Deliveroo category, as I mentioned, individuals are going to find it really very difficult to demonstrate that they're workers because they won't be able to tick that personal service box. So I think if you're looking at status, considering whether there's an appropriate right of substitution and an unfettered right of substitution can be really helpful if you want to be clear that you've got a genuinely self-employed workforce. Jess, would you just give me the next slide, please? I think actually we need to step on to the next one as well. Thank you. So why do we care about this? Why does status matter? As we've touched on, there are three categories of status in employment law. So we have employees, we have workers, and we have those who are self-employed. And the reason that organisations like Uber, Addison Lee and Deliveroo spent a lot of time and money litigating on the status of their workforce, and remember that litigation was focused on whether the individuals were engaged as workers or self-employed, is principally because workers enjoy some significant rights and benefits. And again, if we think of our sliding scale, employees at one end enjoy the full suite of rights and protections, self-employed individuals enjoy none, and workers who sit in this kind of middle zone will enjoy some rights and protections. And some of these are actually quite significant, including from a cost perspective. So importantly, if you're a worker, you're entitled to receive the national living wage, you're entitled to get paid holiday, and you're entitled to pension contributions. And it really was the cost implication of a determination that the workforce were workers that drove a lot of the litigation that we've seen in this area. Now, the other important thing to remember is that although workers don't enjoy protection against unfair dismissal, they do have protection under discrimination and whistleblowing law. So I think the takeaway is to proceed with caution if you're looking to do something to a consultant or a contractor that you wouldn't do to an employee. For example, how you might treat them in the context of a long-term illness that might amount to a disability, or if they're, say, pregnant. And because if they are workers, they might still be able to bring a discrimination claim. So practically, what should you all be doing about status in your organisations? If you haven't already done so, it's really sensible to do an audit of your workforce to make sure that you've got a grip on the types of individuals you're engaging and what their status will be. and to keep this under review, because someone's status can change over time. And it's not at all unusual to have someone start out as a truly self-employed contractor and over time become more integrated into the business, such that they might become a worker, or even in some cases become an employee. The final point I've just got on the slide, it's really just a flag, because it's a complicated topic in its own right. But if you engage consultants through personal services companies, and if your business is caught, so if you're what we call a medium or a large company, you're also going to have to consider the application of the off-payroll rules. So they came into force, I'm sure all of you will recall, in April of this year. And effectively that takes you down another process route where you have to do a separate status determination for your consultants and potentially make PAYE deductions from their fees if they're what we call deemed employees. So if we could have the next slide, please, Jess. Thank you. So I'm just going to finish my section this morning by touching on 3 important Equality Act cases that we've had recently, and some key takeaways that businesses should really be considering now in light of these. So the first is the case of Bayfield, and in that case, an advertising agency acted effectively too hastily in addressing its significant gender pay gap. So days after a conference presentation, which was called Crisis, the Mother of All Change, and which was delivered by a director appointed to help the agency lose its reputation as a Knightsbridge boys club, the 2 claimants, who were white, middle-aged creative directors, were dismissed by reason of redundancy. Now, both of the claimants had raised concerns about aspects of the presentation that was delivered, which included a statement that the agency wanted to obliterate its reputation for being full of straight white men. Now, here the Employment Tribunal accepted that the agency's desire to reduce its gender pay gap was a perfectly legitimate response. However, it found that the claimants were not scored fairly during the redundancy process. So the tribunal determined that the scores and the comments that had been made to justify the scores were themselves acts of direct sex discrimination, i.e. a senior female team wouldn't have been scored in that same way. And in essence, what had happened was the agency started from a place where they wanted the outcome of the redundancy to be that these 2 white men left because they were men, and they reverse engineered the scoring accordingly. Now we'll look at takeaways in a moment, but here the agency, in a sense, was trying to do the right thing and fix a very real problem of gender inequality in its senior team. But they potentially partially fixed a problem in one area and created a very real problem in another area. And frankly, it's never attractive for an employer, whatever the reason, to have findings of direct discrimination. So moving on to the case of LA, this is an employment appeal tribunal case in relation to a claim of racial harassment. And an employer, importantly, will have a defence to this type of claim if it can show that it took all reasonable steps to prevent the discriminatory treatment. Now, in this case, the defence failed, and the EAT agreed with the first instance tribunal that the employer couldn't rely on what was considered to be stale equality and diversity training. Now, this training had been conducted almost 2 years before the claimant began his employment and almost 3 years before his dismissal. And the appeal tribunal made it very clear that when you're looking at the reasonable steps defence and whether the fact that you run training can bring you within it, you need to really give careful consideration to the nature of the training and the extent to which it was likely to be effective. The fact that in this case, the harassing employee who had completed the training still thought that their racist comments were banter, and that other colleagues, including managers who'd also completed the training, took no further action, really evidenced the fact that this training was insufficient, and so the defence wasn't available to the employer. Now, in defending these types of discrimination claim, it's not at all unusual for an employer to run a reasonable steps defence, as part of which they will say, we ran some diversity and inclusion training, so that should bring us within this defensive cloak. And I think this case is really important to highlight the fact that it's not a tick box exercise. If you want to gain the protection of the reasonable steps defence, you really shouldn't expect to get much traction by relying on what was put here as a stale, kind of outdated old training course. And then just moving on to my last slide, please, Jess. Thank you. So the final case I want to look at is this University of Oxford case. And here we have the appeal tribunal again, looking at two cases of Pitcher and Ewart, and they both related to a compulsory retirement age, which, although directly age discriminatory, can be lawful if the employer can objectively justify the discriminatory treatment. And in the EAT decision, we effectively had the appeals tribunal upholding both tribunals' original decisions, although they'd reached actually very different conclusions. So in the Pitcher case, the first instance tribunal found that the compulsory retirement age was objectively justified. So although it was prima facie age discrimination, the University of Oxford could rely on the defence of objective justification. But in Ewart, a different tribunal found that this objective justification defence wasn't available to the university. Now, in both of those cases, the tribunal found that there were three potential legitimate aims which you might be able to use to rely on the objective justification defence. And these were promoting intergenerational fairness, facilitating succession planning, and promoting equality and diversity. And the appeals tribunal agreed that they were all legitimate aims, but they could only be objectively justified in Pitcher, and they couldn't be objectively justified in Ewart. And on the face of it, that's quite an odd decision because we're looking, broadly speaking, at the same compulsory retirement age at the same institution. But the reason, well, there are a couple of reasons as to why we have this divergence in conclusion. So first of all, in Ewart, the tribunal had the benefit of some statistical evidence, which actually showed that the retirement age had a really trivial impact upon the creation of vacancies. So although in theory it might facilitate succession planning and intergenerational fairness, in reality, in Ewart, the tribunal could see that that wasn't really happening on the ground. And the second thing that happened in these cases was that the tribunals received different evidence on the detriments suffered by those to whom the retirement age applied. And what that meant was that they could give different weight to the mitigating factors that were relied on. So what we have here are two tribunals looking at the same compulsory retirement age, reaching different decisions, but a finding by the appeals tribunal that neither tribunal had made any errors in law, and so both conflicting decisions have been upheld. And I think the really important takeaway from these cases is that if you're trying to run an objective justification defence, which you might do for direct age discrimination or other types of indirect discrimination, it's really important you make sure you have the actual evidence to support what you're saying. Just because obviously if you don't, you can end up with very different judicial findings. Okay, so can I have my final slide, please, Jess? Thank you. So in terms of takeaways, I cannot claim credit for this action acronym. That will go to Kerry, who is going to be talking to you next. But just to run through these points quickly, the first is to carry out an audit. So work out what is going on in your workforce. Do you need to take any steps to address the inequality in recruitment, in pay, or in other areas? The second is to be careful of the pitfall of reverse or positive discrimination, and that was really highlighted in that Bayfield case with the advertising agency. Make sure you're training staff on these issues regularly. Don't just tick a box and think you'll be able to rely on out-of-date training that was run years prior to an incident of discrimination. A subset of audit, but also consider what impact your policies and practices might have on groups with protected characteristics, so you can anticipate potential discrimination issues. And where you are trying to rely on objective justification to justify direct age or indirect discrimination claims, make sure that you properly evidence your legitimate aims and why a prima facie discriminatory approach might be appropriate. And make sure you're doing all of this now, not later, because as is often the case, taking a proactive approach tends to be better than reactive. You can make sure that you're in control, which invariably you lose a little bit of when you're reacting to a complaint. So I'm now going to hand over to Kerry, who's going to start our section on hot topics for the year ahead.
Good morning, everyone. I'm Kerry, the PSL in the team. I'm going to speak today about flexible working and specifically the topics that we think are going to feature prominently next year. Flexible working is an obvious choice because many of you are now operating hybrid policies, and we saw that 38% of you require employees on a hybrid policy to come into the office at least 2 days a week, which I think is fairly common practice. We think it's a trend that's going to continue because people are reevaluating their work-life balance. And over the last few years, our clients have certainly seen an increase in the number of individual flexible working requests that they've been receiving. The government has had flexible working on its agenda since the Good Work Plan was published back in 2019, but it only launched a consultation on making flexible working the default in September this year. The consultation actually closed last Wednesday on the 1st of December, and we're expecting a response early in the new year with some clarity on the future changes. There are 5 main areas of focus in the consultation. First, the introduction of a day one right to request flexible working. And the key point to note is that it's not an immediate right to work flexibly or a right to work from home on a permanent basis. It's just a removal of the current 26-week service qualifying requirement. The second thing to mention is that the consultation considers whether changes are going to be needed to the current 8 statutory reasons that employers can rely on to reject a request. So at the moment, for example, you could reject a request on the basis of the burden of additional costs or the detrimental effect on your ability to meet customer demand. It's not a given that these reasons will change. I think the government would rather not interfere with them, but we'll have to see what comes out of the consultation response. The third thing is whether employers should be required to suggest alternatives if the employee's original request is not going to work for the business. That's a complaint that employees often raise, the fact that their request was simply rejected out of hand without any engagement over alternative options. The fourth thing to mention is that the consultation considers changes to the administrative process that underpins the right to request flexible working. So, for example, whether the 3-month time limit for an employer to respond is still appropriate, and whether employees should be entitled to bring more than one flexible working request in a 12-month period. And lastly, the consultation considers raising awareness of the existing right of employees to request a temporary trial period for flexible working. Can I have the next slide, please, Jess? But in the meantime, please do continue to follow the current statutory flexible working process because it hasn't changed. So broadly, if you receive a request from an employee who meets the qualifying criteria and hasn't already put one in the last 12 months, then you've got 3 months to deal with it in a reasonable manner. And generally that's going to involve meeting with the employee to discuss the request and then confirming your decision in writing, unless of course you're in a position simply to agree it. In terms of a few points to bear in mind, please don't delay or reject a request just because you've got a firm-wide agile or hybrid working policy in place. And this doesn't actually override the obligation to respond to individual employees. What it might mean in practice is that the specific request they raise can't actually be accommodated as easily if you have huge sections of the workforce working flexibly. But do remember that an individual request can still only be rejected on one of the 8 statutory grounds. Best practice would be to think about alternatives that the business can accommodate if you're unable to accept the first request. And please do think about discussing these with the employee. Trial periods can also be a useful way to try changes out for size, provided you're crystal clear that it's not going to be a permanent change to terms and conditions, and any change will remain subject to review. And as always, managers should aim to deal with requests promptly, effectively, and consistently. And we think a paper trail of the reasons behind your decision would also be a good idea. There's the potential for a tribunal claim based on a failure to follow the statutory process itself, but more significantly, there's the risk of an indirect sex discrimination claim. And the recent Thompson case is a good example. ScanCrown found themselves on the hook for £185,000 when they mishandled their sales manager's request for flexible working on her return from maternity leave. She'd asked to adjust her working hours to a 5 o'clock finish so that she could pick up her child from nursery, and the estate agency refused to budge from its standard 9 to 6 p.m. working day. and they gave 5 business reasons why they couldn't accommodate her request. But the tribunal held that the business concerns didn't really outweigh the discriminatory impact on Ms. Thompson. And I do wonder if Scan Crown had suggested an alternative that could have worked for both parties, or perhaps a trial period, then it's possible that they could have avoided a breakdown in the working relationship. Next slide, please, Jess. So moving on to the new duty to prevent sexual harassment, which the government has confirmed will be introduced when parliamentary time allows. It's an unsurprising development given the importance of the topic over recent years and the increased scrutiny on employers from areas like the press and regulators, and also the Equality and Human Rights Commission. At this stage, we don't have much to go on in terms of content. We're still waiting on the draft legislation, but we know that there's going to be a new proactive duty to take all reasonable steps to prevent sexual harassment. And the government's view is that intervening with legislation will encourage employers to take positive steps to promote inclusive working environments. It's anticipated that the trigger for an individual claim will be the occurrence of one specific incident of harassment. And it's also anticipated that greater involvement from the EHRC will occur. And the intention is that the EHRC will supplement its current technical guidance with a new statutory code of practice. And the aim is to provide you with some guidance on the reasonable steps defence, albeit at the moment there's no intention to introduce a prescriptive list of steps to follow. There will also be new protection from third-party harassment, for example, by external consultants or clients or suppliers even. And you may recall the previous third-party harassment regime, which was overturned in 2013. Under that, liability kicked in after 2 previous incidents of harassment. And it's not currently clear whether only one incident will be needed with the new duty, but we do know that employers will have the reasonable steps defence available to them. So you will have a chance to reduce risk and take upfront protective measures. Finally, but quite significantly, the government is looking closely at extending the time limit for Equality Act claims in the tribunal from 3 to 6 months. So unfortunately, we might end up with 2-tier timing. Say an unfair dismissal claim would still be a 3-month claim time limit, versus perhaps an age or a sex discrimination or harassment claim, which could potentially have a new 6-month time limit. So not remotely confusing. Next slide, please. In light of these upcoming developments, what do we think you should be thinking about? Well, it would be a good idea to look at your existing policies and check whether they're robust and fit for purpose. Have a look at third-party agreements and consider what compliance responsibilities you're putting on suppliers or external consultants, for example. Are your existing reporting mechanisms still effective? Does everyone understand how they can go about raising concerns? Communication is always at the heart of good workplace policy, so make sure that staff understand that you'll take a zero-tolerance approach to harassment and that you'll enforce it with disciplinary action if needs be. Encouraging an open speak-up culture is also quite important and expected by certain regulators, such as the FCA, for example. Employees should feel safe to report inappropriate behaviour, and they need to believe that there won't be any negative consequences for them if they do so. And also don't forget that harassment can take place online, so make sure that everyone understands your approach regardless of their work location. Finally, you can embed all of these points with effective training. So start with the onboarding process, follow up with regular training to all staff, and make sure it's a top-down approach, so those who have reporting lines know how to deal with harassment sensitively. I also just want to mention the upcoming employment bill. We're still waiting for that, but it's likely to incorporate some further changes, and that includes a new day one right to a week of unpaid carers leave, up to 12 weeks of neonatal leave for parents with a child in neonatal care, and a prospective extension of protection from redundancy for women on maternity leave. And that would kick in from the point they notify their employer through to 6 months after they've returned to work. So over to Jane now to talk about strategic absence management, which we think is another hot topic for the upcoming year.
So good morning, everybody. It's nice to be talking to you, albeit that I can't see you. What I'm going to be talking to you about, and I should perhaps just mention who I am. I'm Jane Mann. I'm one of the partners of the firm. But back to the topic in hand, we wanted to share with you a few thoughts that we'd had about your approach to the overall management and prevention of ill health at work. We've been very struck by the wide range of ill health issues affecting the workforce and employers. And we believe that there are now these issues are now a strategic business issue for boards and excos to be considering as a matter of strategic business issue for the board agenda and the exco agenda during 2022. I'd be interested in the views of other people on this who may be on the call. Do feel free to email me. But we've put on the screen here the list of the many ill health issues that we've seen affecting employers during the course of the year. To state the absolutely obvious point first, which is that there seem to be very high COVID infection levels affecting employees. And the thought is that this will continue. It's not going to go away, and that it will continue as the illness becomes endemic and will continue to be an issue that employers need to manage. COVID, of course, is something that most people get through fairly easily, but it can be the cause of a serious illness for some very unfortunate employees. And we have also seen in our client companies quite a few occasions when employees are suffering from long COVID, where there are serious long-term effects after the initial infection. Many employers are also dealing with vulnerable employees, those who have underlying health conditions which make them particularly anxious about attending work and vulnerable to more serious illness from COVID. Of course, there's been a lot written about and talked about in the media about stress and anxiety, but that's something I think that employers are actually seeing on the ground as an issue that they have to deal with in their workforce. And it's come about partially sometimes through work, but increasingly also from non-work related issues, the level of isolation that some people have experienced at home and various other strains in their life that have caused them to become unwell. And that, I think, is a very real issue for many of the employer clients we have. Another thing that I think is really impacting on the workforce and the management of ill health is delays in the NHS system and possibly also the private system for getting treatment to people. We know of quite a few situations where employees are waiting for important operations and treatment. They're on a waiting list and they can't get the treatment and they're at home unwell in the interim. And of course, there is the tragedy and difficulty associated with people whose illnesses have been missed. They haven't been diagnosed in time and are now much more serious than they would have been otherwise. All of these presenting issues for employers. Employers have also had to deal with a lot of disruption relating to the COVID rules, and they're all back at the moment, relating to isolation through contact with people with COVID, and a lot of travel restrictions which have people stuck at home and isolated until they get their PCR tests, or possibly stuck abroad until they are clear to travel to come back. Something which is tangentially related to COVID, but is not just about COVID, is the increase in older employees at work. They are, of course, more vulnerable to adverse effects from COVID, but also people who are more vulnerable to illness and those that need to be protected from ill health more than perhaps the younger workforce. COVID has put the spotlight on other infectious diseases and the onus on employers to take more steps than perhaps was the case in the past to prevent the spread of infectious diseases such as flu and gastro infections amongst the workforce. And as something that Jess mentioned earlier on in her talk was the situation of employees caring for ill relations or disabled relations at home. And that, of course, is on the increase as well, with an aging population and with people in that group suffering from more illness. The overall picture, I think, is that employers will have to deal with many more issues related to ill health of their employees or their employees' relations, and many more issues relating to the prevention of ill health and dealing with their responsibilities to prevent ill health. So on the next slide, thank you, Jess. We've put down a sample of the liabilities, risks and costs that this picture of increasing ill health represents for employers. The obvious point is loss of productivity and escalating sick pay costs, and also the difficulty of arranging cover where many people are absent through ill health. One of the things that slightly mystified me in the past was how employers tended not to budget for and plan for ill health and absence, because it was bound to happen. People do get sick, and in today's world, quite a few more people are getting sick, and that is something that employers need to plan for, budget for, and make practical arrangements for cover. Most employers, and this was shown in the poll at the beginning of this session, have a caring attitude to employees and are very concerned to put in place protection for employees in the event that they become ill, and have sick pay policies that enhance sick pay over the statutory level, medical expenses insurances in many cases, and permanent health insurance. And these, of course, are highly desirable, but come at a cost, which employers have to budget for. The pandemic has put the spotlight on health and safety policies to prevent ill health and COVID in particular in the workplace, but it doesn't just apply to COVID, it applies to all the risks that present employees who come to work. And I think employers are now much more focused on their duties to risk assess the possibility that people will become ill, and to look critically at their own policies to take whatever steps they practically can to prevent ill health at work. The disability laws have been referred to by my colleagues already. Employers are required to make reasonable adjustments to facilitate returns to work of people who've had a spell of ill health and are now disabled, or disabled employees in general. And these all cost a degree of money, but are of course very important to allow equal access to workplace. Employers have for years navigated their way through difficult procedures to deal with people who are unable to work through ill health. They take a while and they're quite complicated, and that is something that involves management time and cost. Discrimination claims have been mentioned in the context of COVID by my colleagues, and there are quite a few potential discrimination claims that relate to ill health, in particular disability, and claims relating to age are the particular areas of concern. In our practice, we've seen quite a few personal injury issues raised where employees in particular have become ill through stress at work and allege that their employers have negligently caused their ill health. And there seems to be more people alleging this and more employers having to deal with defending such claims. All of the above involves not just cost, but also a significant impact on the management time involved in dealing with all of the issues above. All of this leads us to think that there ought to be a more strategic approach to the management and prevention of ill health at work. Jess, perhaps you could put my final slide up. So here we leave you with a few thoughts about what should be in a strategic action plan to be considered possibly at board or exco level. First point, budget accurately for and plan resourcing by reference to actual and projected absence levels. People will get sick, and it's as well to plan for it and to work out what the level of sickness you can expect is, so that you know how to cope with that in terms of resourcing and costing and budgeting for it. Review systems to ensure that accurate absence recording is in place, and that you know what the extent of the problem is. That's obviously been rendered a little bit more difficult by the working from home. People are not as visible as normal, or rather their absence is not as visible. So that's something to review. Procedures need to be in place for managing ill health, including the flexible policies that have already been talked about, not just for childcare and those types of issues, but also for enabling people to care for disabled people at home, ill people at home, and also flexible policies where people have become ill themselves and they need adjustments to be made in their working patterns. One thing that employers often struggle with is developing a good relationship with an occupational health provider. Our view is that a good occupational health provider, and by the way, they're not all good, but many are, is a really valuable tool for employers. I've mentioned already health and safety risk assessments and policies and the need to ensure they are up to date, reviewed regularly and implemented properly. A particular issue for employers is likely to be thinking that it's all over when COVID dies down a bit and that's that, we don't need to do this anymore. But actually our recommendation is that you do and you keep this going. Review your schemes for protecting employees, sick pay entitlements, medical expenses, insurance, permanent health insurance, and in particular the claims record of the companies that you place your insurance with. Some PHI providers, in our experience, are very bad at accepting claims, and we have to have quite significant fights with them to get legitimate claims accepted. You don't really want that if you're relying upon a policy to protect your staff. And finally, just a word of congratulation to everyone on the efforts that have been made to promote the health and well-being of staff at work. We have been really impressed by how far employers have gone to introduce measures to help employees stay healthy. Mental health counselling, medical screening, and a whole range of other measures. So just to end on a positive note there, it's been a pleasure talking to you, and I'm now going to hand back to Jo, I think, who will wrap us up.
Thank you very much, Jane, and thank you also to all of our speakers, and a particular thank you to Jess, who's doing her first HR Law webinar this morning. And Jess, we've had one question in, so you get the honour of answering the question on your first webinar. So that is, what if clients are requesting only vaccinated staff to be sent to carry out work, perhaps in an offshore environment? How is this best managed in terms of keeping vaccine records?
So, I mean, an easier option would be just to ask the employee to show you evidence of their vaccine, but not actually record the data. But you'd obviously have to check with the client that that's okay with them and just let them know that you're only conducting a visual check. If you do need to record the data, then it will be processing health data. And so to comply with GDPR, you'll need to consider what lawful basis you have for processing the information. And you'd need to carry out a legitimate interest assessment, update the privacy notices, and consider questions such as why you're processing the information, inform the employee why it's being recorded and the purpose of processing the information. Also, how long you're going to store that information. I guess if the employee is only working overseas on a specific project or a specific task, then it's probably more likely to be appropriate to just conduct a visual check rather than hold on to the personal data.
Thanks very much, Jess. And we've just had another question in. I'm not sure whether people have views on this one, but a very interesting topic. Where do you see engagement with neurodiversity on employers' list of priorities? Anyone got a view on that? Or shall I answer that?
I just had one comment to make on that. I mean, I think that diversity and inclusion is a huge topic for employers moving forward over the coming years. And I think that neurodiversity is an element of that and is something that should be relatively high on the agenda for employers as we head into the future.
Yeah, I think we've not. I've not personally been asked to advise on any issues relating to neurodiversity, but I am aware that it is on clients' agendas, as Kerry said, in terms of their overall agenda around diversity and inclusion. And I think I think we're seeing more webinars, seminars, etc. on this very topic. So it's quite clear that it's a topic which people want to find out about and to start thinking about their own processes and policies around neurodiversity. I don't know if anyone else had anything to add to that.
Just to echo both Jo and Kerry have said, I was at a conference with a lot of kind of HR directors based in the city recently, and neurodiversity was its own topic. You know, it was a panel discussion and it was something that got an awful lot of audience engagement. So I think, you know, it is really something that people are thinking about in terms of optimizing the kind of breadth of talent you might have within your workforce and promoting that inclusivity agenda. So I think it is something that is getting quite senior levels of attention at the moment as well.
Yeah. Jane, did you have anything to add to that?
Well, I was at the same conference, so I share that perspective, but also just as a manager and someone in business for a long time, I actually think it's been a very neglected topic. And I think it's really important that it goes up the agenda personally, because I think a lot of people have been held back in their careers by this, and they could have been more successful if they'd been better supported. So I actually think it's, just from experience, a really important issue for everyone to address.
Yeah, thank you, everyone. So another question just come in. Daisy, this might be for you, given your topic this morning, but please others chip in. What would you suggest if a manager refuses to offer reasonable adjustments to an employee who suffers from severe anxiety and stresses at work, and the condition has been recognised under the Equality Act by Occupational Health?
Yeah, so I think we might be in a conversation about the reasonableness of the adjustments required, because whenever you're looking at adjustments you can make, you are entitled to operate within this kind of parameter of what you can reasonably accommodate. It's not the case that just because someone might have a recognised disability under the Equality Act, they get kind of carte blanche for whatever adjustments they might ask. So I think probably the exercise is really interrogating the manager to try and work out if what they're refusing is reasonable. Why is that the case? And also, are there any other alternatives? Because we've had kind of some case law in this area where actually tribunals will scrutinise decision making, and they'll want to understand your thought process as an employer. And I think the kind of easy thing sometimes is for managers to say, that's just too difficult, I don't want to engage with it. And that's not enough. I think you really, and as the sort of HR professional approaching it, I think it's important that you put the manager under some kind of scrutiny and you sort of challenge why they're forming that view, so that you can kind of get to a place where you're comfortable that there are good business reasons as to why it can't reasonably accommodate it, if that is the case. And if it isn't, then I think you, in a kind of risk management exercise, because potentially you've got a kind of credible claim sitting there.
Yeah, and I've certainly found that it sometimes focuses the manager's mind when you point out to them that if they continue to dig their heels in and refuse the reasonable adjustments, if there is a credible claim, as Daisy said, then they would be a key witness in that claim, because they'd have to discuss the reasons why they refused the adjustment. So if the softly approach doesn't work, that approach does tend to focus minds. Great. Well, look, I think that's all the questions we have. Thank you to everybody who's sat and listened in this morning. I hope you found it really useful. The topics that we've covered are topics that we have written about on our HRLaw free online service, led by Jane and the team, and it's really helpful having your questions because it gives us a clue as to some of the areas that we might cover in the future. If you don't subscribe to those emails, or if you do and you'd like colleagues to, please just drop Jess Bennett a line, or anyone of us, or your usual contact at Fox Williams, and we can sign you and your colleagues up for those updates. And we'll certainly be covering, I think, some of the topics, particularly that Kerry mentioned, as things become a little clearer throughout the course of the year. So thank you, everybody, for attending, and I really hope that we're all able to enjoy a happy and healthy Christmas this year without too many restrictions on who we can see. So thank you from everybody on behalf of the team, and goodbye.